Most of us have heard of Plessy v. Ferguson, right? It's famous for being this devastating loss for civil rights, the case that locked separate but equal into law for decades. But what if I told you that loss was actually the final step in an incredible, carefully designed master plan? Today, we're not just looking at a court case. We're going to peel back the layers and look at the story of its architect.
So, let's start with a really big question. When a law is just flat out wrong, how do you even begin to fight it? Especially when the whole system is built to work against you.
Do you just sit back and wait for it all to fall apart on its own? Or do you become an architect of resistance? Do you actually design the perfect stress test, a super precise experiment to expose its deepest flaws for everyone to see? Well, that is exactly what happened here.
To really get the plan, first, we gotta understand the target. Our story kicks off with the legal villain of the piece, Louisiana's Separate Car Act of 1890.
This law put into writing a phrase that would haunt America for more than half a century. It demanded equal but separate spaces on all trains running within the state of Louisiana. Now pay really close attention to that phrase, equal but separate, because as we're about to see, the equal part was almost always a complete fiction.
So the rules were simple and they were brutal. You get on a train, you get sorted by race. If you don't comply, you're looking at a $25 fine, which, trust me, was a lot of money back then, or even jail time. But here's the twist, the one crucial detail that the resistance was about to exploit. The railroad companies themselves hated this law. Not for some moral reason, but because it was just plain expensive. Running extra train cars costs a lot of money. And this opposition created a little crack in the system, a crack that the architects of our story were about to blow wide open.
So who were these architects? You know, every master plan needs a mastermind. And in this case, it wasn't just one person. It was this brilliant group known as the Comité des Citoyens.
Okay, so this Committee of Citizens, formed just a year after the law passed, was an incredible coalition. You had 18 New Orleans residents, black, white, and multiracial Creoles. And these weren't just anybody. We're talking about lawyers, business owners, writers, and activists. And they had one single laser-focused goal, to systematically take this law apart, piece by painful piece.
And you better believe they were serious. They put their money where their mission was, raising around $3,000 to fund the whole legal battle. I mean, this was a massive fundraising effort for the 1890s. They got support from unions, churches, all kinds of community groups. This number right here just shows you how organized and how determined they were right from the get-go. So they had the team, they had the money. Now they just needed the plan. And this wasn't just some vague idea to protest. No. This was a sophisticated, multi-layered blueprint for a total legal takedown.
Their strategy was just brilliant, with three main parts. First up, publicity. They used a member's newspaper as a megaphone, to get the public on their side and control the story. Second, direct action. They weren't going to wait around for some random person to get arrested. They were going to stage their own arrest, controlling every single detail. And third, litigation. They went out and hired one of the best civil rights attorneys in the country, Albion Tourget, with the clear goal of taking this fight all the way to the Supreme Court.
With that blueprint in hand, it was time to go. It was time to put a very carefully measured weight on the system and see exactly where it would break. But even the best plans don't work perfectly on the first try, which, honestly, just highlights their genius. Their first test case involved a man on a train headed to another state. Well, the case got thrown out because a state can't make rules for travel between states. It was a small win, sure, but it didn't actually challenge the law itself. So what did they do? They learned, they adapted, and they designed a second, even better test. This time, the trip would be entirely within Louisiana, a trip that would force the courts to deal with the law head-on. And the man they chose for this mission was Homer Plessy. Now, his selection was nothing short of a strategic masterstroke. Plessy was of mixed heritage, 7/8 white, and he could easily pass for a white man. And that was not a coincidence. That was the whole point. It was the core of their legal argument. How can you possibly enforce a law when the very idea of race is so arbitrary that you're leaving it up to a train conductor to be the judge?
So the whole thing, the arrest, was basically a piece of theater, and every single actor knew their part. Step one, they got the railroad company to play along. Remember, the company didn't even want this law in the first place because it was costing them money.
Step two, the committee hired its own private detective to make the arrest. Now, why would they do that? It was pure genius. This ensured Plessy was charged with one thing and one thing only, violating the Separate Car Act. No disorderly conduct, no disturbing the peace, just a clean, focused legal challenge. And then, the final step, the trigger for the whole operation. Homer Plessy, sitting in the lights-only car, identifies himself to the conductor. And just like that, he sets the entire pre-planned machine in motion. It was an absolutely perfectly executed plan.
The case wound its way through the courts, exactly as they had planned, all the way up to the Supreme Court. But the outcome, well, it was not what the Comité had hoped for.
The verdict was a crushing 7-1 decision against Plessy. The court officially established the doctrine of separate but equal, basically giving a legal green light to segregation all across the country. On the surface, it looked like the master plan had completely and utterly failed.
But in that one dissenting vote was a powerful seed of the future. Justice John Marshall Harlan wrote this furious, prophetic dissent, arguing that the Constitution is colorblind, and his words, they became a rallying cry, a moral and legal argument that future generations would pick up and run with.
And this is why this story isn't about a simple loss. The plan's true impact, it unfolded over decades. The very same arguments forged by the Comité and their lawyer, Albion Tourget, became the literal blueprint used nearly 60 years later to win Brown v. Board of Education, the case that finally struck down segregation in schools. Their plan didn't fail, it just had a really, really long fuse. And in 2022, that history came full circle, when Homer Plessy was finally pardoned.
So, that leaves us with one last thing to think about. The architects of this plan, the Comité des Citoyens, they lost their case in 1896. No question, they lost the battle. But when you look at the decades that followed, at the legal victories that were built directly on top of their work, you have to ask yourself, did their blueprint ultimately win the war?